Hello everyone. So in this video, we have covered the polity section of Vision IAS monthly magazine from February 2025 till November 2025. So there will be one more video which will cover the remaining months before UPSC Prelims 2026. So I hope that this video is going to be helpful for your revision.
Only take 10 minutes. So first is related to freebies. So understand, freebies basically means government is giving a lot of things free of cost. Usually it is used as a trick to woo the voters. There is a difference between freebies and welfare. Usually welfare basically focus on the capacity building. For example, providing quality education, healthcare. Freebies, on the other hand, have an intention to attract the voters. So, for example, we will give, let's say, cylinder free, or we will give this thing free, that thing free. What is the problem with this approach? Two things are happening. A, government need to spend more money on these initiative. Basically, this is a kind of revenue expenditure which will keep on increasing every year. So government will have less money for capital expenditure. That's first thing. Second thing, it created dependency culture. So people may not have willingness to work. They think that, okay, government will provide us free of cost things, so why to work? So these are some of the issues related to this entire thing. So basically, Supreme Court questioned whether the freebies are fostering a parasitic lifestyle. Parasitic lifestyle basically means living on the resources of someone else, not willing to work. Next is related to status of devolution to Panchayat in states. See, recently this report was in news because it was released by Ministry of Panchayati Raj. 73rd and 74th Amendment provided constitutional status to PRI, that is Panchayati Raj institutions, and ULB, that is urban local bodies. Now understand, the concept of Panchayat is that power should remain close to the people who are the actual source of power. Whenever we talk about preamble, the first keyword is we the people. So basically they are the ultimate source of power, and through Panchayat we are giving them this power. Okay, now there are a few important parameters of this index. First parameter is framework. Framework basically means the constitutional provisions, whether they are followed or not. Second thing is function, that means what are the responsibilities or roles played by them. Third thing is finance, whether they have ability to generate revenue or not, to what extent they are dependent on the grants. Then functionaries, that means how good is the performance of the panchayat officials. And last is capacity building, that simply means whether we are able to empower them or not. So these are the 5 parameters of this Panchayat Devolution Index. Next is related to the concept of proxy representation. Proxy representation basically means, see, the constitution has provided reservation to the women in the 3rd tier. However, even after election, the majority of the tasks are performed by the male members of her family. This is referred as a proxy representation. So 73rd Amendment provided 1/3 reservation for the women. In certain states, it is even 50%. For example, Bihar was the first such state to provide 50% reservation to the women. But the problem is that on paper, women are the representative. In reality, the functions are performed by the male member, and that's why there is a concept like Sarpanchpati. So this particular issue highlight that we need to give them actual empowerment, or we need to consider the real power. Merely providing reservation is not sufficient. We have to make sure that these power are exercised by the elected female representatives rather than their male counterparts. Next is related to deregulation commission. See, deregulation basically means reducing the compliance burden to promote the ease of doing business, or to promote the, or to simplify the business environment. In that context, government is going to set up a deregulation commission. This was highlighted in the budget as well. Apart from that, the economic survey also highlighted that Deregulation is the need of hour to promote the economic growth. In this context, government also introduced Jan Vishwas bill. Now, in a very simple sense, previously a lot of simple activities were considered as a criminal offense. For example, delay in filing papers. I'm just giving random example. Now, previously it was a criminal offense in case of certain compliance. Now, government has replaced that criminal offense as a civil offense. So, in a very simple sense, rather than jail punishment, there will be some type of fine. So, why it has been decriminalized? Decriminalized basically means previously it was a crime. Now, it is not a criminal offense, it is just a civil offense. Or in certain cases, that has been removed from the list of offenses. Why it is being done? To improve the business environment. Now, on similar lines, to promote efficiency in the administration, the US government have set up Department of Government Efficiency, which is under Elon Musk. Next is related to Manipur. So recently, the Chief Minister of Manipur resigned. President rule was imposed under Article 356. 352 is for national emergency, 356 is for president rule in the state, and 360 is for financial emergency. Since Manipur is under president rule, the budget of Manipur was presented in the parliament. Punjab was the first state to come under this president rule under Article 356. Next is related to the amendment in the Waqf. Understand the term Waqf. It basically means the properties which are dedicated exclusively for religious or charitable purpose under Islamic law. In a very simple sense, these are the properties which are considered as a property for Islamic purpose. Okay, they cannot be sold for any other purpose, and this is prohibited. Now, for the management of such properties, there is Waqf board. For better management, government have introduced certain changes through this bill, and these changes are introduced on the basis of recommendation of Rajendra Sachar committee. Now, in one line, what is the objective? Objective is to improve the regulation of Waqf properties. One of the most significant amendment is that previously, if there was a dispute whether it is Waqf property or not, it was decided by a Waqf tribunal and the decision was final. Now what has been done through this amendment, the decision of that tribunal can be challenged in High Court. Apart from that, there is one more significant amendment. Now even non-Muslim members will be part of the management team through that Waqf board. So these are two important things which you need to keep in mind. Next is related to digital brand identity manual. In a very simple sense, the Ministry of Electronics and Information Technology have specified a standard format for the government documents. Digital brand identity basically means digitally this is going to be the brand of entire country or entire administration through these websites. So basically the emphasis is on simplification of e-governance. What is e-governance? Delivery of services to the citizens through digital medium. So these were the important parts of polity section. Thank you. One more thing, the PDF of this entire document is available. Please check the link given in the description box. You don't have to do anything. Just read this PDF, basically revise it, and your magazine is done. Okay, now let's start. First is related to judicial accountability. Understand the background. So recently there was a news that cash was found at the residence of High Court judge, and subsequently there was issue of judicial accountability. Now understand, judicial accountability basically means judicial system is accountable or not. Now the problem is that the action can be taken against judges. One is impeachment can be done, but this entire process is so complex. Second is in-house inquiry committee. In-house inquiry committee simply means the Supreme Court will set up a committee to investigate the matter. The criticism is that this is quite opaque, this is quite complex, and that's why there is a lack of judicial accountability. Now, Another problem is that judges are appointed by judges themselves, basically through collegium system. So to address this part, NJAC, that is National Judicial Appointment Commission, NJAC Act was enacted. However, that was declared unconstitutional by the Supreme Court. So basically, the focus is on, again, how we can ensure judicial accountability. We have to reenact that National Judicial Commission, or we have to introduce transparency in the appointment of judges. Second thing is that there was a Judicial Standards and Accountability Bill. However, that bill had lapsed. So basically, we have to reintroduce them to ensure accountability and transparency in the judicial system. That is all about this first article. Second is related to regulating big tech, that means big technology related companies. Now understand CCI, that is Competition Commission of India. It is set up as per Competition Act of 2002. Now the objective is to ensure fair competition. That simply means to take action against monopolistic practices. Monopolistic basically means against those companies who show their dominance or monopoly. The problem is that this is ex post model. What is ex post model? Ex post model basically means event has happened. Now someone is going to file complaint against this anti competition practice, and subsequently CCI will look into it. Recently there was Digital Competition Act. Basically this is a new proposed legislation which focus on ex ante. Ex ante basically means before the occurrence of that event, CCI will look into those circumstances so that the incident does not happen. What kind of incident I'm talking about? Basically the monopolistic incident does not happen. What is monopoly? In a very simple sense, let's say Google is a search engine. So if you are going to search anything on Google, there is a possibility that Google can give priority to its own results. That means the results which favor Google. So that is all about monopoly. And in that context, in this new proposed legislation, there is a concept of SSDE, that is systemically significant digital enterprises. In a very simple sense, these are very big technology related companies, and therefore we have to regulate them extra. Why there is a need of extra regulation? So that they do not show, or though they do not misuse their monopolistic position. That is all about this entire new digital legislation. Next is related to a bill which is related to immigration and foreigners. So basically it tried to repeal the existing provisions, and it tried to modify the current provisions related to immigration and foreigners. So existing acts such as Foreigners Act, Passport Act, Registration of Foreigners Act, and Immigration Act, these are being repealed through this bill, and it tried to streamline this entire process through one legislation. Now this bill have stringent provisions for those who enter into our country as immigrants. Basically, it specifies that hospitals and universities need to report the foreigners who enter into India, and it also talks about the strict punishment, jail punishment of 5 up to 5 years, and of 5 financial punishment of 5 lakh rupees fine, up to 5 lakh rupees fine. So in a very simple statement, in one line, this tried to streamline the process related to the immigration. Immigration basically means someone from other country enter into our country. Immigration and foreigners. Next is related to Standing Committee on Rural Development and Panchayati Raj. So this committee have highlighted certain issue. One issue is budget allocation has gone down. Second issue is that the certain schemes are not implemented properly. For example, SVAMITVA scheme, this was not able to achieve its physical target. Through the SVAMITVA scheme, basically we are preparing the new maps with the help of drone technology. Then there is a lack of trained manpower, there is a lack of financial resources, and then there is a delay in the election of the third tier institution, that is Panchayats. So that is all about it. Next is related to dedicated cell for mercy petition. So Supreme Court had given a guideline to the states that they need to set up a specific or dedicated cell so that this cell can process the mercy petitions. Mercy petition simply means someone is on death penalty and they have applied for mercy. Okay, to process this or to speed up this entire process, there will be a dedicated cell. This was the guideline of the Supreme Court. Subsequently, Maharashtra government have set up a dedicated cell, and that this will be under additional secretary to speed up the processing of mercy petitions. Next is Sansad Bhashini initiative. Sansad means parliament, Bhashini basically means related to language. So since in parliament different politicians speak different languages, that's why there is a provision of multilingual parliamentary operation. In a very simple sense, with the help of technology, we are translating their speeches into different languages, and the name of this project is Sansad Bhashini project. So for this, Lok Sabha and Ministry of Electronics and Information Technology have collaborated. Next is related to future of free speech index. So this is an index released by US based think tank. Basically, the objective is to show the free speech in any country. As per that, India is on 24th position out of 33, and countries like Norway, Denmark, and Sweden, they are on top position. So that's all for polity related current affairs. Thank you. Hello everyone. So in this monthly magazine of Vision IAS April 2025, we are going to cover the polity and governance section. Now let's start. So first article is related to separation of powers. Now understand, separation of power basically means judiciary, executive and legislative branch of government, they are separate. Now understand, in case of India, there is a constitutional supremacy. That simply means constitution is supreme. Now why this entire issue of separation of power was in use? There were various judgments by the Supreme Court, and the legislative and executive branch were not happy. They are saying that this is a judicial encroachment. Encroachment simply means judiciary is encroaching in the territory of executive and legislative branch. However, from exam perspective, you need to understand that in case of India, there is a constitutional supremacy. In case of countries like UK, there is a parliamentary supremacy. Parliamentary supremacy means parliament is supreme. But in our case, it is the constitution which is supreme. Next is related to approval of state bills. So recently there was a judgment by the Supreme Court, and the name of the case is State of Tamil Nadu versus Governor of Tamil Nadu. In this case, the Supreme Court specified the timeline for the governor to approve the bills. Now understand two, three important things. This is state legislature. So they will send the bill to the governor. Now, governor can send this bill to the president. So for this, the duration is 3 months. Governor can approve it or withhold assent, but if governor is sending it for reconsideration, and if the state legislature send it after reconsideration, then governor is bound to give approval. So these are important dimensions you need to keep in mind. Now, this is an interesting timeline. See, if state legislature passes a bill, it will be sent to governor, and governor will have four choices. Number one, A, approved. Approved simply means now it will be a law. Second is the assent is withhold. So that simply means bill is rejected. Third is return the bill for reconsideration. Now, of course, in case of money bills, this will not be applicable. If it is sent for reconsideration and if the state legislature passes it with or without any amendment, governor is bound to give assent. Now, this is not the case with the president. President is not bound to give assent even after the bill is sent by the state legislature, even after the reconsideration. And fourth is reserve this bill for the presidential consideration. Okay, now once a bill has been received by the president, that simply means the bill which was referred to the president by the governor, then president can take three actions. A, president can approve it. It will be a new legislation. Second, president can withhold the assent. Third, president can send it for reconsideration. Now, the state legislature must reconsider within 6 months, and it is not mandatory for president to give approval even after it is being sent, even after reconsideration. So that is something which you need to keep in mind, that for governor it is mandatory, but for president it is not mandatory to give approval even after reconsideration. Next is related to states' demand for autonomy. So recently, Tamil Nadu government was in news because they had set up a committee to look into the issues related to power between central and state. And this committee will be headed by the former Supreme Court Justice, that is Justice Kurian Joseph. Now, in that context, that simply means in the context of federal provisions, various other committees are important. One is Raj Mannar Committee, which was set up by the Tamil Nadu government. Then Anandpur Sahib resolution. This was related to Punjab, or in a very simple sense, state versus central government. And then there is West Bengal memorandum. Now, understand two, three things. Tamil Nadu is having conflict with the central government or government of India over various issues. One such issue is NEP, that is National Education Policy. Then there is a issue of NEET. Then there was issue of governor. Then there was issue of use of rupee symbol in Tamil language. So these are some of the controversial provisions. Now understand, the accusation of Tamil Nadu government is that central government is imposing Hindi on us as a part of national education policy, and since we are not accepting it, we means Tamil Nadu is saying, since we are not accepting it, the central government is not releasing fund under the centrally sponsored scheme such as PM Sri schools. Centrally sponsored basically means that a central government is providing financial resources, and rest of the resources will be provided by the state government. Next is related to 5 years of SVAMITVA scheme. So SVAMITVA basically refers to survey of villages and mapping with improvised technology in village area. In a very simple sense, it is drone based survey. Why it was in news? Because it completed 5 years. It is a scheme by Ministry of Panchayati Raj. Next news is related to the post of Deputy Speaker of Lok Sabha. Understand, the post of Deputy Speaker is vacant since 2019, and that is why this entire issue was in news, that this is a kind of problem in the constitutional arrangement. It should not have been vacant for so long. Now understand, the office of Deputy Speaker that emerged in 1921 as per the provisions of Government of India Act of 1919, and Dr. Sachidanand Sinha was the first Indian who held this office. Next is related to inaction by the speaker on the defection. In a very simple sense, defection means after election, the elected member, they are switching the political parties. To address this problem, there was anti-defection legislation. This was introduced through 52nd Amendment or 52nd Constitution Amendment Act. Now, as per this, if there is a defection, the decision will be taken by speaker. So this defection is specified in the 10th schedule, or anti-defection legislation or anti-defection law was specified in the 10th schedule of Indian Constitution. The decision will be taken by speaker, but there is no timeline that how much time will be taken by the speaker. That's why Supreme Court said that the indecisiveness of speaker is not a right thing. That simply means the speaker should take this decision within a time frame. It is similar to governor judgment, but in that judgment Supreme Court had specified the exact duration. In this case, the court has not specified the duration. Okay, now understand one more thing. The judgment of speaker is subject to judicial review as per the Quixote Holland case. So that is something which you need to keep in mind as far as anti-defection legislation is concerned. Now one more thing, if there is a split in the party, or if there will be merger, Will there be anti-defection law in that case? Means will it be applicable in that case? Please write down in the comment section. Next is related to immigration and foreigners bill. This was covered in the previous month magazine also, so nothing important is here. It is just a new bill which is going to repeal the existing provisions, and it will simplify the process related to immigration and foreigners entry into India. Next is related to Panchayat Advancement Index. In a very simple sense, what steps are being taken by panchayats to achieve the goal of sustainable development? So this index reflects the performance of panchayats. It is based on 9 such themes or 9 development themes. These themes are such as, for example, poverty, child friendly panchayat, clean panchayat, and so on. Now understand in a very simple sense to what extent they are achieving the SDG. So there are 4 categories. These categories are achiever category, then front runner category, performer category, and aspirant category. Maximum panchayats are in aspirant category. Gujarat is leading the front runner category. There is no state in the achiever category. That simply means no state has achieved 100% of their targets. So no state is there in the achiever. Now in this context, recently Panchayat devolution index was also in news. Panchayat devolution. So this was covered in the previous month. And as per this index, Karnataka was on top position. And this was actually released by Panchayati Raj Ministry, but it was prepared by Indian Institute of Public Administration. In this case, that is in case of PI, that is Panchayat Advancement Index, Gujarat is on top position. So these were the important current affairs of Vision IAS monthly magazine of April 2025, and in this we had covered the polity section. Next one will be IR. Thank you. The highlighted PDF is available. Please check the link given in the description box. Okay, now let's start. So first news is related to caste census. Understand, recently government announced that in the upcoming census, caste data will be collected. So far, caste data of scheduled caste and scheduled tribe was collected. Let me give you a very brief background. In 1931, basically in 1931 census, caste data was collected and released. At that point of time, there were roughly 4147 caste. In 1941, data was collected but not released. So caste data was collected but not released. Now, from 1951, the data of SC and ST was collected. Rest of the data was not collected. Okay, that is the status. Now government has said that in the upcoming census, the data of entire caste will be collected. That's first thing. Second thing is that there is SEC, socio-economic caste census. Socio-economic caste survey. So basically, in this case, this was conducted in 2011. In this case, the data was collected, but for policy formulation. Understand, in this case, the people were asked about their caste. There was no fixed formula or there was no fixed pattern that you have to select from these castes. They were asked what is their caste, and that's why there were a lot of redundant data or lot of duplicacy, because same caste is known in the form of different names in different areas. So roughly there were 46 lakh such communities. So that is why the government is saying that this time we are going to conduct it properly. Now in this upcoming census, two important developments are there. One is this caste data, second is digital collection of the data. So this time we are collecting it using digital devices so that we can streamline this data in a more appropriate manner. Now understand, a census is very different from survey, caste survey. Caste survey is conducted by the state governments. Karnataka government was the first one to do so. Later Bihar and Telangana also conducted their own caste survey. Census is conducted through the Home Ministry, that is a Registrar General of India, that means through central government. Our survey are through state government. That's another difference. Third is this SCCC. This was through Ministry of Rural Development. Okay. Now understand one more thing. Census is in the domain of union list. So that's why state government cannot conduct this one census. They can conduct the survey. Next topic is related to private members bill. So understand there is a PRS report which simply highlighted that the contribution of the private member bill has gone down. Now first thing first, what is private member bill? Private member bill basically means a bill which is introduced by someone who is member of parliament but not a minister. Member of parliament but not a minister. That's the difference between the government and the private member. So even if someone is from ruling party, they will be referred as private member if they are not part of the minister, or simply if they are not minister. Okay. Now, what is the problem? Why their contribution has gone down? There are multiple factors, but in a very simple sense, there is a partisanship in the house. Partisanship basically means more time and attention is given to the government bills. Government bills basically means bills introduced by the ministers. That's first thing. Second thing is that the private members do not have that much resources for research and development. Basically, for research on the issues, and that's why this article basically talks about following the UK model. In case of UK, there is a specific committee for research on the bills, which will provide assistance to the private members. So that is second article. Now what is the process? Understand, first thing first, who is private member? Any member of parliament who is not a minister. And it is a private member bill basically means a bill introduced by the private member. So they will have to give 1 month notice to the speaker or to the chairperson, depending on Lok Sabha or Rajya Sabha, and then the time is allocated. So in Lok Sabha, last 2.5 hours are allocated every Friday. In Rajya Sabha, every alternate Friday, 2.5 hours are allocated. First successful private members bill was Muslim Waqf Bill of 1952. Next topic is related to inclusive digital access under Article 21. So understand, in his recent judgment in Amar Jain versus Union of India, the Supreme Court highlighted that digital access is a part of Article 21 itself. Now understand, let me give you a brief background. So there is a concept of KYC, know your customers. Bank have issued various guidelines for KYC. These are based on RBI guidelines. Okay. Now problem is that these KYC require face data. Okay. Now certain victims of acid attack, they are not able to provide this information because of changes in their facial structure due to acid attack, and that's why they were facing problem in accessing their bank accounts. So in this background, the Supreme Court said that digital access is also a part of right to life and liberty under Article 21. In this matter, please understand the role of the term digital divide. Digital divide simply means those who have access to digital technologies and those who do not have access to it. Next is related to power of court to modify the arbitral award. Now, let me give you a brief background of this entire issue. See, one is our judicial system, and one is alternate dispute resolution. Alternate to what? Alternate to regular judicial system. That simply means to resolve the disputes outside this conventional judicial system. Okay, what are the mechanism to resolve the dispute? They are basically referred as MAC: mediation, arbitration, and conciliation. Okay, now if there is any judgment or if there is any award through arbitration, this A stands for arbitration. So if there is a judgment through this arbitration, basically it is referred as award. Can it be challenged in Supreme Court or can it be challenged in court? In a very simple sense, And can court change this award? That is the entire issue. The Supreme Court in Gayatri Balaswamy case highlighted that yes, court has power to change this, but it is very, very limited power. So there is this limited scope to modify under Arbitration and Conciliation Act of 1996. Now understand one thing. On what grounds the award or the judgment through this arbitration can be changed? So it can be done in specific circumstances. For example, there is some invalid issue. For example, there is some error, or if there is change in circumstances after that incident. So in that case, the court can intervene. Otherwise, usually court will not intervene. Understand the problem here. This system is relatively slow. This will take time. And that is why this ADR mechanism has been set up, especially for commercial interest. See, if there is a commercial dispute, the dispute resolution need immediate solution. Otherwise, it will have adverse impact on the business. If the judicial route is taken, it will slow down the process, slow down the resolution process. That's why ADR is there. If court will intervene in every other judgment through ADR, then it will again slow down the process. That's why the Supreme Court said that we are not going to intervene immediately. We will intervene only if there is some exceptional circumstance, and the intervention will be very, very limited. So that is the meaning of this entire thing. Now understand, Supreme Court can give a judgment, or Supreme Court can intervene under Article 142 to ensure the complete justice. So just remember, Supreme Court can give directions under Article 142 to ensure the justice. Now this arbitration is part of ADR. ADR is outside the formal judicial system. We have already discussed that. Next is related to Rohingyas. So understand, Rohingyas are the Muslims. They are from Myanmar. Originally, actually, they are from Bangladesh who got settled into Myanmar. In Myanmar, they faced persecution. That's why they are now entering into different countries, including India. So they are illegal immigrants. Now, there was a case in Supreme Court that they should not be deported back. Deported basically means they should not be sent back. Now, understand, India's argument is that we are not signatory to this refugee convention. That means we are not legally obliged to provide shelter to these people. We are not signatory to any such protocol or convention. That's first thing. Second thing, India's argument is that we are a highly populated country. There is already pressure on our resources. Why we should allow illegal immigrants to increase pressure on our resources? So that's why this matter was in court. The court said that no, India is not liable to provide them shelter, in a very simple sense. So this was the judgment of the court. So court said that the basically the government of India is not bound to provide relief or facilities to these people who are Rohingyas. Rohingyas are ethnic minority group from Rakhine state in Myanmar who faced persecution. Okay, then they fled to different countries, including India. Understand, India is not a signatory to this 1951 UN Refugee Convention or its 1967 protocol. That means legally we are not bound to provide shelter. It depends on case to case basis that is being decided by the government. Next is right of pedestrians. So understand, in a very simple sense, Supreme Court has said that right to footpath, that is a part of right to life and liberty under Article 21. So two important things are there. A, we should have footpath so that a pedestrian can walk on it. Second thing, it should be accessible for differentially abled people. So two important things: footpath should be there, they should be accessible. Now there are two major problems. A, in most of the cases footpath are not there. So the court had said that roads must have footpath for people to walk. That's first thing. That's our fundamental right. Second thing is that in most of the cases, even if there is footpath, they are being encroached. So basically, these encroachment need to be removed so that people can walk on these footpath. So that is the judgment of court. In a very simple sense, the court has issued direction that there should be mandatory footpath on all the public road and remove the encroachment so that people can walk. Apart from that, they should be accessible and differentially able friendly. Differentially able friendly basically means that differentially abled people should be able to use them. That simply means they should have ramp. And last news is related to the 50th anniversary of Sikkim's statehood. Understand? Sikkim was initially included in India as a associate state, and later it was given the status of full-fledged state. So in 1974 through 35th amendment, it was granted the status of associate state under Article 2A. Later this was repealed, and through 36th amendment in 1975, Sikkim became the 22nd state, full state. Sikkim is given special constitutional safeguards under Article 371F. So these are the important current affairs of Polity section of Vision IAS Monthly Current Affairs Magazine of May 2025. In next section, we are going to cover IR. Thank you. If you have any doubt, please write down in the comment section. I will try to respond to that. First news in Polity section is related to 50 years of emergency. So emergency was imposed in 1975, to be specific, on 25th of June, and it lasted till 1977. Now why it was imposed? One of the most important factor was there was JP movement, which was led by Jayaprakash Narayan. So basically it was total revolution movement, and subsequently there were other issues also. For example, inflation was quite high, unemployment was there, and there were various pressure on our resources because of the influx of migrants due to 1971 war. Apart from that, the Allahabad High Court had ruled, or basically the election of then Prime Minister Indira Gandhi was declared as invalid, and that is why she had imposed emergency. Now after emergency, there was a Shah Commission. So Shah Commission was set up to look into the misuse of power. Now as far as emergency is concerned, please understand the emergency. So there are three important articles. Article 352, that basically talks about the national emergency, which can be imposed on the grounds war, external aggression, and armed rebellion. Previously the term was internal disturbances, but through 44th amendment this term armed rebellion was introduced. 44th amendment. Okay, so these are important things. Next is related to personality right. Understand, we are living in the age of AI. Anyone can clone your face, can clone your voice, and they can use it for commercial purpose. So basically that is a violation of your personality, because you were not you have not given any kind of permission to do so. So that is why recently Delhi High Court protected Sadhguru Jaggi Vasudev's personality right from being misused by AI generated deepfake and voice clone. Voice clone basically means your voice is replicated even though you have not given explicit permission. What is deepfake? Deepfake is simply a content which appears genuine but it is fake. So it seems that it is authentic content, but it is not so. So personality right basically means your voice, your face, your name, all these are part of your personality, and they should not be used without your prior approval. Now in our country they are not clearly defined, and that is why they are prone to misuse. Recently Denmark was in news because Denmark is implementing a new law to protect the individuals from AI generated content. That simply means no one can clone your voice without your explicit permission. Next topic is constitutional validity of narco test. Understand, narco test basically means a substance is given so that the person does not lie. What substance is given? It is sodium pentothal. So basically the objective is to find out the truth about the incident. Now as far as narco test is concerned, please understand one thing: the involuntary narco test, that means without your permission, they violate the constitution. How they violate constitution? One is Article 20, that is right against self incrimination. So there are three components of Article 20. No double jeopardy. That simply means you cannot be punished twice for the same crime. Of course, a departmental inquiry is allowed, and there is no self incrimination and no ex post facto. Now, no self incrimination basically means you are not going to incriminate yourself, and no ex post facto basically means the criminal legislation will not have retrospective application. Retrospective basically means from back date. Okay, so voluntary tests are allowed, but involuntary are not allowed because they are the violation of the Article 20, and Article 21 is right to life. So that cannot be done. Now, in this case, understand one more thing. The test directly cannot be used as the sole evidence. Sole evidence basically means the content from the test. Let's say criminal said that I killed someone. Merely this cannot be used as evidence. Based on this particular statement, the police authorities need to find out, let's say, weapon. And then that weapon can be used in the investigation. So that weapon can be an evidence, but this statement alone will not be sufficient evidence. Next is related to Quality Council of India. So understand, it was in news because of its new office. The office is, or new headquarters is going to be in New Delhi. Now understand, QCI, that is Quality Council of India, it is a public-private partnership. Now what is this public-private partnership? Public-private partnership, let me write it down properly. Public-private partnership basically means both government and private player are coming together. So various industry body, for example, SOSAM, CIA, and FICCI, they are being represented in this QCI, and the Prime Minister appoint the chairperson of QCI. This has been asked by UPSC in its prelims. So just remember this thing. Next is related to ECI net. As the name suggests, it is an application by Election Commission of India. Now, what is the objective? Objective is to report the voter turnout more efficiently. So it will provide the updates related to voter turnout. Next is related to Adi Karamyogi program. Karamyogi basically refers to all the Karamyogi initiatives are focused on one thing, that is capacity building. Capacity building. Okay, Adi basically means we are referring to tribals here. So this is an initiative of Ministry of Tribal Affairs. What is the objective? Objective is to build a network of motivated officers for the welfare of the tribal communities. So we have to train the field level workers up to 20 lakh. So that is the objective. We need to create a workforce that is committed towards the welfare of tribal communities. So with this, the polity section is over. Now let's revise this entire thing. Just a second. So first issue is related to 50 years of emergency. Again, nothing much here. You have to cover the polity section, static part. And this is about personality right. That simply means your voice, your face, your name cannot be used without your prior permission. Then narco tests are invalid if they are done without your permission. Why? Because it is in conflict with Article 20 and Article 21. Then QCI, it was in use because of its new headquarter office building. The Prime Minister appoint the chairperson of QCI after consultation with the industry. Industry basically means we are talking about the industry representatives, for example, FICCI, that is Federation of Indian Chambers of Commerce and Industry. Okay, then ECI launched a new app which is going to provide reports related to voter turnout, and Adi Karamyogi program. Okay, good morning everyone. So in this video we are going to discuss the Vision IAS monthly magazine, and this is July 2025 edition. Okay, first we are going to discuss polity related articles. So first article is related to digital colonization or digital colonialism. Understand, in a very simple sense, Britishers colonized us. Now after 1947 we became independent, but what is happening is that lot of developing countries, they are still dependent on the technology from the developed world. This is a new form of colonization that is basically referred as digital colonialism. So the issue is that there is a control of digital infrastructure by the foreign big tech companies from the developed countries. And that's why there is a criticism that they basically have control over data from the developing countries, because most of the servers are situated in these countries. And that's why there is a criticism of free flow of data versus data localization. Countries like India say that the data of Indians should be stored within India. On the other hand, countries like US and European Union countries, they focus on the free flow of data. They say that there is no such requirement or restriction to store data in that country itself. Why? Because most of the servers are situated in these countries, and data is the new oil. So that's why there is a criticism that if we will allow our data to be stored in those countries, what will happen if that data is stolen? We will not have much jurisdiction in those countries. So basically that will compromise our digital sovereignty. So 3-4 terms are there: digital colonization, digital sovereignty, free flow of data, and data localization. That is important from this particular article's perspective. Rest of the things are quite common, which you can read on your own. Second is online content regulation. So in a very simple sense, because of digitization, there is online content, and in that context, information and broadcasting ministry have banned various ott platform content for obscene content. Now understand, the criticism of this entire decision is that now you are trying to suppress the creative expression. On the other hand, the argument of the government is that the article or the right of freedom of speech and expression, that is not absolute. There need to be reasonable restrictions on the ground of morality, on the ground of public health. There need to be reasonable restrictions, otherwise it will create chaos in the society. So you just need to understand, INB ministry imposed certain restrictions under what rule? Under Information Technology Act of 2000 and IT rules of 2021. Basically the objective is to protect the vulnerable section, for example, to protect women, child, differentially abled people. Now understand, if there won't be any limit on the freedom of speech and expression, there will be innumerable instances of let's say cyberbullying. So that's why the government is saying that there need to be certain reasonable restrictions. Now, these are the legal provision. Understand, there is one article related to the protection of children, and that is POXO, protection of children from sexual offenses. Now, because of digitization, the vulnerability of children has increased. Government is saying we need to protect them. For that, there need to be certain restrictions. Next is related to national cooperative policy. Now, first thing first, what is a cooperative society? Cooperative society basically works on the principle of mutual benefit. That means benefit of each and every stakeholder. For the promotion of cooperative societies, the government has recently announced the National Cooperative Policy. This is second such policy after 2002. Now, what is the objective? Objective is basically to increase the contribution and role of cooperative society in overall economic development. Why cooperative societies are so significant? Because A, they will promote the economic growth and development at grassroots level. That's why they are quite significant. On the other hand, 2025, that is being celebrated as International Year of Cooperatives. So that's why from exam perspective also, cooperatives are quite important. Now, what is the objective? Objective is to engage 50 crore inactive or non-members and to increase the contribution of cooperative societies, that is to increase their contribution in overall economic growth. Now, how we are going to achieve that? So we will promote inclusivity, we will use technology, we will focus on the entry of cooperative society in a new field. For example, most of the cooperative society are now operational in the field of dairy sector. The government is saying we will also promote them in sectors such as let's say cab sharing. So that is how we will increase the reach of these cooperative societies. For that, government also established a separate ministry, and in that ministry there will be a dedicated cell for the implementation of this policy. Next is related to the report on PRI finances. PRI basically refers to Panchayati Raj institutions. Now understand, these PRI institutions, they face problem of finance. Why? Because they are dependent on the state and central government for financial resources. And that's why their functions and functionaries are adversely impacted. In a very simple sense, since they are financially dependent, they cannot play a bigger role at local level. So this report highlight that only, that even after the constitutional status to these institutions, they face the problem of functions, fund and functionaries. They are dependent on the grants from the central and state, and they have very low amount of own resources. For example, their own resources are roughly 1.1% of total resources. So that itself shows that how much dependency is there. Next is related to interstate water dispute. Now understand, water is a state subject, and because of the role of the because of the boundaries of different states, there are various disputes. Because we have withdrawn this, or we have drawn new states, but our rivers, they do not understand these political boundaries, because our states are not drawn according to geographical circumstances. They are drawn from the administrative perspective. So that's why there are water related dispute. Water is a state subject. Understand, Article 262 empower the parliament to adjudicate water related disputes, and subsequently River Board Act was enacted in 1956. It will have advisory role. And then there is Interstate Water Dispute Act of 1956. It talks about the tribunal mechanism to resolve these disputes. Now, what is the issue with this? There are a lot of delay in the award or the judgment of these tribunal. Apart from that, there is there are various allegations of politicization of these issues. For example, let's say there are two states. In one state, the political party is similar to that in central level. So that's why there are allegations of partiality, and there is a lack of enforcement of those awards, and that's why these issues are recurring. Next is cost of politics in India. Understand, this article simply highlight that we spend too much amount of money on elections. Elections are now more about spending more and more money. And that's why what happens is that the person who is not financially that much capable won't be able to participate in this entire election process. Participate in the sense that they won't be able to contest elections. And this will adversely impact our democracy. So what need to be done? There need to be a transparency in the entire election funding process. Apart from that, you can also provide recommendations of Goswami committee, which had recommended state funding of elections. This will also promote, that simply means if there will be lack of transparency in election funding, this will also promote crony capitalism. Now, what is crony capitalism? Let me give you a very basic example. Businessmen will fund political parties so that they can win election. Now, why they are funding political parties? Because once these parties will win election, they are going to give contract to these same businessmen. So that's why it is being said that if there won't be any transparency in the funding process, it is very difficult to ensure the democracy. Because ultimately, in a democracy, the funding process must be transparent. In that context, you can also write down the judgment of the Supreme Court in the electoral fund concept, that there were electoral bond which Supreme Court had declared unconstitutional because they lacked transparency. Next is related to lowering of age for voting. So various countries are saying that they are planning to reduce the voting age from 18 to 16. Now there are certain arguments in favor, certain argument against it. Argument in favor is that yes, it will increase the role of young people into the election. What are the criticism? Criticism is that these people are not that much mature that they can understand the consequences of their vote. So what need to be done before reducing this age? First, we need to spread awareness regarding our entire election system, and then we can reduce the voting is, how we can increase awareness. For example, civic literacy program can be organized. Youth parliament, for example, there is a good example. Bal Panchayat concept is there, which is being implemented in various states like Gujarat and Maharashtra. What is Bal Panchayat? Basically, it is the panchayat of children. So they will learn about the voting process, the entire decision making process. That will spread awareness regarding our entire election system. Next is related to disruption of parliament. So basically this article says that there are frequent disruption in our parliament, and that is why the productivity is adversely impacted. For example, the Lok Sabha functioned for 88% of its scheduled time, and Rajya Sabha worked for only 73%. So there are two major issues. A, the amount of time allocation, that itself is very less. Within that time, there are a lot of disruptions. That's why the productivity is quite low. So, for example, in 1950s, the parliament met for 120 to 140 days per year. Now, that has gone down to 60 to 70 days. Just imagine, the highest lawmaking body meet only for 60 to 70 days, and within that also, the productive time is very less because of the regular adjournments. So that's why this article says that it will adversely impact the legislation making process. There will be a lot of loopholes in these legislation, and that's why they will be challenged in the court also. So there will be poor drafting, there will be poor debate. Why? Because of lack of time. What will happen? Without debate, they will be passed, and then they will be challenged in the court. Next is related to removal of judges in the higher judiciary. So understand, there is a proper process of appointment and removal of judges. Now, recently, why it was in news? Because of the issue of High Court judge. Caste was found. Subsequently, in-house inquiry committee was set up. Subsequently, the parliament uh, discussed this issue, and a committee, inquiry committee of parliament was set up to investigate this issue. Now, understand the process, detailed process of this removal of judges is being discussed in Judges Inquiry Act of 1968. What are the grounds? Grounds are proven misbehavior or incapacity. And this entire process is governed as per the provisions of Justice Inquiry Act. Next is related to National Standards for Civil Service Training Institute. Now understand, there is a Karma Yogi initiative. That is basically capacity building initiative for the civil servants. Capacity building basically means how to improve the capacity of our bureaucracy. So in that context, this initiative was launched. This NSC STI 2.0. What is NSC STI? That is National Standards for Civil Services Training Institutes. So this was launched by Ministry of Personnel, basically by the Minister of State for Personal, Public Grievances and Pensions. Now this has been developed by Capacity Building Commission, which is under Mission Karma Yogi. What is Mission Karma Yogi? It focuses on the capacity building. And last news in the polity section is related to bills of lending bill. Now, again, let me give you a very simplified example. Let's say you want to parcel something. So you contacted, let's say, DTDC or India Post for that matter. Again, it is oversimplification. So you are going to hand over your item to India Post. India Post is going to give you a receipt that this is the item, this is the weight, this, that. That is basically referred as the bill of lading. So bill of lading is a legal document which is issued by the freight carrier. That simply means the company which is going to transport your item to the shipper. So you are the shipper in this case. India Post is the freight carrier. So for simplification of this, recently this bill was introduced, and this focus on modernization of shipping and maritime trade documents. The paperwork will be done in a simplified manner. So these were the important articles which were discussed in the Polity section of Vision IAS monthly magazine. The PDF is available on the Civils Academy app. Thank you, and that's all for the day. Now, in Polity, first is related to 130th Amendment Bill. So this has been introduced for the removal of Prime Minister, Chief Minister, and other ministers who are detained for 30 plus days in the serious criminal cases. That simply means if someone is detained for more than 30 days, these ministers, they can be removed. So just remember two important things as of now, because it has been recommended to JPC, that is Joint Parliamentary Committee. So 30 plus days, and it is applicable on Prime Minister, Chief Minister, and other ministers. Now, why it has been introduced? See, government is saying that the objective is to decriminalize the politics. Criminalization of politics basically means in entry of more and more criminals into the political sphere. Decriminalization basically means we want to remove them. So that is the argument of the government. What is counter argument? Counter argument is that central bodies such as CBI, ED, IT department, these bodies basically they are under the domain of central government. So central government can misuse them against the state. And that's why the criticism is that it is a violation of federalism, because now the central government will be able to control the chief minister. So that is the criticism. Now understand two, three important things. Three bills are there. Three constitutional amendment bills are there. One is for central government, then for Jammu and Kashmir and Puducherry. Okay, so rest everything is this is Jammu and Kashmir and Puducherry. Now this is against the principle of natural justice. See, natural justice principle says that there is innocence until proven guilty. That means until and unless you are convicted, you are innocent. But in this case, we are removing the person from the post just because the person has been detained for more than 30 days. Detention does not mean conviction. This stance is also highlighted in Lily Thomas case, in which Supreme Court said that the punishment will start immediate after conviction. In this case, conviction is not there as of now. First, there is detention. Conviction may take time of, let's say, 5 years or maybe more than that. So that is one problem. Second problem is in Manoj Narula case, the Supreme Court said that we need to introduce the element of morality. What does that mean? That means moral people should be in the politics. For that purpose, the Supreme Court said that the Constitution does not bar criminally charged ministers, but there is a requirement of constitutional morality. That simply means Constitution does not remove those people if there is a allegation of crime against any particular minister, because until unless the person is convicted, there is no way to remove those person. That's why the government has introduced this bill. So these are some of the common arguments in support and against it. You just need to read it. Okay, now coming to next topic. Just a second. So just remember these three things as of now. First is this thing, that it will be applicable to UTs as well as to the states. Two judgment, one judgment in favor, that is Manoj Narula judgment is in favor of this bill because it talks about constitutional morality. Then Lily Thomas judgment is against it because that says that the punishment will start after conviction. In this case, we are punishing someone even before their conviction. Next is related to the Promotion and Regulation of Online Gaming Act. See, before discussing this, understand two major concepts. One is game of chance, one is game of skill. Game of skill basically means your skill set is involved in that game. You are winning because of your skill set. Game of chance basically means it is luck based. There is no element of skill in this case. Recently, the government has introduced this bill, and subsequently it was in news because it has banned the money based online games. Government is saying these are game of chance. That is pure gambling, and that's why government has introduced this. Now understand why there is a requirement of central government involvement. Usually gambling is prohibited by the states, but this is talking about online aspect of it, and that's why central government had to intervene. But it does not impose a ban on the esports. What are esports? For example, cricket. Computer game of cricket will be E refers to electronic version. So it does not prohibit them. In fact, it tried to promote them. So it tried to promote the skill-based gaming and e-sports. That is something which you need to keep in mind. Now understand, the government is saying that because of these gambling, there are a lot of issues. For example, addiction is there, mental health related issues are there. That's why government has introduced this. The government define online games through this, and it basically promote the esports. Rest of the things are quite common. Next is related to national sports governance. As the name suggests, the objective is to simplify the governance process. For that purpose, there is going to be a body and that body is referred as NSB. What is NSB? National Sports Board. So this is going to give recognition to different sports federation. Now understand the point of criticism in this case. Sports is a state list subject. So states are saying that this is encroachment into our domain. Central government is saying that we are talking about the broader regulation. We are not talking about the minor regulation. You are still free to introduce those regulations. Apart from that, the government also emphasized on strengthening NADA. What is NADA? National Anti-Doping Agency. That simply means prohibition of the drug and other substances like that in sports. So this body is responsible for that prohibition. That simply means it implement those rules and regulations and it take action against that. Next is related to Jan Vishwas bill. See, as whenever you see this term, just remember one term: decriminalization of certain offenses. Understand? See, previously, let's say there is a business, and previously, let's say if you are not going to file the papers on time, then there is a punishment, and this is a criminal offense. There may be a jail punishment. What government is saying that why not to simplify these rules? Instead of giving jail punishment, just impose a penalty. So that's why government is trying to simplify this process through these Jan Vishwas bills. The objective is to decriminalize the minor offenses. Decriminalize basically means it won't be a criminal offense. It will be a civil offense. Civil offense basically means you need to pay some kind of fine or penalty. You will not be jailed. That is the difference. So government, you can use this argument whenever you are specifying that government is promoting ease of doing business. So in that context, it is important. So there has been decriminalization of minor offenses. Please understand, it is not talking about the major or serious offenses. It is just talking about the minor offenses. For example, not filing paperwork. Again, I am oversimplifying. Next is related to the commercial and prohibited speeches are not fundamental right. Now understand, there is a freedom of speech and expression. Now, the real question is whether commercial speech is part of it and prohibited speech is part of it. Commercial speech basically means, let's say there is some influencer who is saying something and he is going to generate revenue from this. Is it protected under fundamental right of speech and expression? That's one question. Second is prohibited speech. Let's say someone is giving hate speech. Is it prohibited? Sorry, is it protected under that right? The Supreme Court has clarified, no, these are not protected. There are certain reasonable restrictions on them, and therefore they are not absolute rights. So in that context, recently Supreme Court has requested central government to provide a broader policy framework for these commercial speech. Commercial speech basically means those influencers. Actually, it is related to that Raina case, that where comedian had made certain remarks against the people who are differentially abled. So in that context, the Supreme Court said that there is a need to provide a broader policy framework. So this was related to a case where there were offensive jokes on disability. Now, commercial speech, for example, ad, influencers, promotions, and prohibited speech. Why we are saying prohibited? Because they are hate speech. They may create hatred in the society. So these are not protected against this. That simply means action can be taken against it. And that's why the court directed the government to draft the social media guidelines. There is criticism of this decision as well. What is the criticism? That it may lead to censorship. Censorship basically means now government will decide what you can speak, what you cannot speak. So government will not allow anything against itself. So that is the criticism. The counter argument is that we do not require extra rules and regulations. Article 19 already talks about reasonable restrictions. That should be sufficient. Now, in this context, two important cases are there. One is Shreya Singhal versus Union of India. In that context, Supreme Court had said that until unless a particular speech lead to violence, there is no need to curb it. That simply means if it does not lead to violence, why to curb it? There is a freedom of speech and expression. So Supreme Court struck down the section 66 of IT Act The court said that only speech causing incitement can be restricted. So that is one judgment. Second case is related to Amish Devgan versus Union of India. In that, the court held that hate speech is not protected as free speech. We have already seen three dimensions. One is that free speech is there. Yes, you have right to freedom of speech and expression, but it does not protect the commercial speech. Commercial speech basically means you are generating revenue or you are monetizing that particular freedom. Second is prohibited speech. In this case, the court had clarified that hate speech is not protected. Now understand, it is very important. In a diverse society like ours, hate speech can create a lot of problems, that too in a very small amount of time. Any hate speech, and it may lead to riots in our country. That's why there is no point in giving protection to hate speech. So that is the major argument. Next is related to overseas citizen of India. So understand, recently the government has amended certain rules and regulations. So one simple rule and regulation is that if someone is convicted, if someone is having OCI card and if they are convicted for a punishment of more than 2 years, or if a charge sheet is filed against them for a crime having punishment of 7 years or more, in that case, what government can do? Government can revoke this OCI card. Now, who are OCI? Overseas citizen of India. Understand, these are those people to whom government of India have issued this card. That simply means they can visit India whenever they want to. They have a kind of lifelong visa. Lifelong visa basically means they have a kind of permission to enter into India. Of course, they don't have other rights such as voting rights and etc. Next is related to election of vice president. Again, vice president had resigned, so election commission is going to conduct the election for the next vice president. Now, vice president is the ex officio chairperson of Rajya Sabha, so that's why it is important. These elections are conducted by EC, and there will be voting, and it will be proportional representation via single transferable vote. Nothing new in this case. You can directly read these provisions in Lakshmikant. Okay. Next is related to NCDC. So understand, 2025 is the year of cooperatives. That's why government is giving focus on this thing. Recently, government also announced national cooperative policy. In that context, recently grant was given to NCDC. What is NCDC? National Cooperative Development Corporation. Now, there can be two type of grants. One is statutory grant under Article 275, and second is a discretionary grant under Article 282. Now understand, cooperatives can lead to rural development. They can help us in ensuring the goal of inclusive growth. That's why the government is giving focus on this particular part. Now, what will be the objective of this kind of grant? Objective is to strengthen the cooperative movement at grassroots level. In polity section, first news is related to criminalization of politics. In a very simple sense, criminalization basically means use of criminal means by the political class. There is one more term, politicization of criminals. That simply means the criminals are entering into the politics. So two terms are there. If politicians are using criminal methods, that is basically criminalization of politics. And if criminals enter into politics, that is basically referred as a politicization of criminals. Okay, so there was a report by ADR, that is Association for Democratic Reforms. As per that, 47% ministers of India have criminal records or criminal cases. Out of that, 27% have a serious criminal cases against them. So that itself reflect the nature. Now, as far as crime as a ground for disqualification is concerned, all these grounds are specified in section 8 of RPA Act of 1951. Now, in RPA, there was one more section. Let's say some person is convicted today. Now, they had a time to appeal against that decision. That is 3 months time was there. You can appeal against it and you will not be disqualified. However, this section 8 subsection 4, this provided this ground. However, this was declared unconstitutional, or it was struck down by the Supreme Court in Lily Thomas case. So it mandated that once a person is convicted, the person stands disqualified immediately. That simply means sitting legislature is convicted and sentenced to 2 or more than 2 years, the person will be disqualified immediately. So that was the judgment of Supreme Court in Lily Thomas case. Apart from that, in ADR case of 2002, Supreme Court said that yes, those who are candidates, they need to provide the details of their criminal background. In this context, recently the Parliament also introduced 130th Amendment Bill. Easy way to remember: after if someone is detained, if some minister, including Chief Minister or Prime Minister, if they are detained for more than 30 days, then that is a ground for removal. They will be removed automatically after that. Yes, they can be reinstated if they are proven innocent in that case. Just a second. Yes, so we have covered ADR, we have covered Lily Thomas case. Apart from that, the Supreme Court in Public Interest Foundation versus Union of India 2019 case ordered that political parties need to publicly disclose the criminal records of their candidates. It should be spread through media, but usually it does not happen that much. So that is about criminalization of politics. Second is related to judicial pendency. Just remember two things. A, roughly 5 crore cases are pending. Roughly 88,000 crore cases are pending in Supreme Court alone. That itself shows that there is a delay in the justice delivery, and justice delayed is justice denied. Now, one major problem is that we do not have adequate infrastructure. For example, we don't have that much amount of courts. Apart from that, there are vacancies in the judicial system. For example, right now we have lower number of judges per population. So as of now we have 21 judges per million, and the recommendation is 50 judges per million. So that itself shows that it is less than half. Apart from that, there is a weak alternative dispute resolution mechanism. See, what happens is that if ADR is providing right kind of platform, then not many cases will go to the courts, and therefore the burden on the courts will go down. Recently it was recommended that we should follow our conventional dispute resolution mechanism of punch system. This was recommended by the minister itself. Apart from that, we don't have sufficient courts, sufficient staffs, digital infrastructure is not up to the mark. Okay, and even the financial allocation is not sufficient enough. Government itself is the major litigant. That simply means roughly 50% of the cases are related to government itself. Okay, these are some of the issues. Now, Supreme Court in Husnaira Khatun case had specified that right to speedy trial is a part of 21. But if there will be delay, then of course it will be against that right. And because of this judicial delay, what happens is that there are large number of under trial people. Now that is why our prisons are overcrowded. So you can connect all these issues. Because of this thing, there is black court syndrome. Black court syndrome basically means people have lost trust in the this entire process, and they are scared of black court. That simply means lawyers, or in a simple sense, they do not trust this system that much. A similar kind of syndrome is referred to white coat. That simply means people are scared of doctors. Okay, in that context, what need to be done? So there is one good recommendation which you can use in your answer, that is National Judicial Infrastructure Authority to upgrade the judicial infrastructure. The rest of the recommendations are quite common. Next is related to National Medical Commission. Why it was in use? Because it was set up 5 years ago, so it completed 5 years. It is a statutory body as per National Medical Commission Act of 2019. It has replaced MCI, that is Medical Council of India. What is the problem with this body? Problem is that it consists of doctors mainly, so it does not have wider representation from society. So if a patient is going to complain, their side is not well represented. So it lacks public health experts, citizen representation is less, and it is dominated by doctors. Okay, next is related to India and French political system comparison. So understand, in case of India, there is a parliamentary democracy, and the head is elected. In case of France, it is a semi-presidential. So president and prime minister both are powerful. In our case, president is a nominal head. So Since president is nominal head, of course, there won't be direct election for the president, so that is quite obvious. But in case of France, since it is semi-presidential, that means both prime minister and president both are powerful, so there is a direct election by the adult suffrage. How prime minister is elected in our country? So prime minister is elected through Lok Sabha. That simply means majority in Lok Sabha. How prime minister is elected in France? So prime minister is appointed by the president, but prime minister need to maintain the confidence in the house. So our constitution or our structure is quasi-federal. Quasi-federal basically means a unique kind of federalism is there. Federalism with unitary biasness. In case of France, it is a unitary structure. What kind of secularism we follow? So we follow a positive secularism. That means a state is going to provide equal support to all religion. In case of France, it is laicite. What does that mean? It simply means there is a separation, strict separation of power between the state and the religion. So these are some of the important differences. Next is related to Vishakhapatnam Declaration. Just remember that it is related to e-governance, nothing much. In this context, just remember one more thing, that recently Albania appointed world's first AI minister. That simply means a technological platform is being used to promote transparency in the government, and this AI platform is referred as DELA. So basically they are referring it as a minister. It's not that they have developed a human being using AI. In a very simple sense, they have adopted a AI system and now they are using it in government decision making. Next is related to immigration and foreigners exemption order. In a very simple sense, who are exempted? So these are the category of people who are exempted. Again, nothing much from exam perspective. Okay, with this, the polity section is over. So 2-3 important things: criminalization of politics, judicial pendency. These are two important issues. Rest of the issues are important, but from prelims point of view, yes, this comparison part, because it is explicitly mentioned in the syllabus, so yes, it is also important from that perspective. Hello everyone, so in this video we are going to cover Vision IAS monthly magazine of October 2025. The objective is to simplify the entire magazine so that you can read the entire magazine in limited time. Please understand one thing, it is not the official YouTube channel of Vision IAS. If you want to download their actual magazine, you can visit the official website of Vision IAS. However, for this PDF, you just need to check the link given in the description box or in the pinned comment. So basically what I have tried to do, I have gone through the entire magazine and I have tried to filter out the most important point. Okay, now let's start. Let's start with the polity section. Okay, now first thing first, it is October edition, October 2025. In polity section, the first news is related to prison reforms. Understand 2-3 important things. The prison and related issues, that is part of state list. Recently it was in news because NCRB, that is National Crime Record Bureau, it has released data related to prisoners. Okay, two important things. It is a topic of state list. That means state government is empowered to legislate on these matters. NCRB is under MHA and it was set up on the recommendation of Tandon Committee. Now, as far as prisons are concerned, 2-3 important things are there. See, our prisons are overcrowded. Overcrowded basically means capacity is, let's say, of 100 people, but there are 120, 140 people are there. That is basic meaning of overcrowding. Why there is overcrowding? The reason is simple. Our judicial system is slow. That's why there are a lot of under trials. Under trials are those people who are into judicial custody, who are not convicted as of now. That simply means their crime has not been affirmed as of now. They are still undergoing the trial, and that's why they are referred as under trials. Now, in this case, just remember two important cases. One is Husnaira Khatun versus State of Bihar. This basically specified that there is a right to speedy trial. However, the problem is that still it takes years and years for the resolution of these disputes, and that's why there are a lot of under trials. So just remember the keyword is speedy trial. One more thing, when you are revising, just revise the yellow highlighted parts so that you can revise the entire magazine in roughly 1 hour. That's why I'm highlighting, so that you can go through the same document and revise while playing the video at the speed of 2 or maybe more than that. Okay, second is Suhas Chakma case versus Union of India. So this is a case of 2024. In this case, basically there was a proposal of open prison. Open prison basically means, try to understand it this way. Let's consider one home. Okay, in home, I'm giving you example in the context of prison. In home, there are different rooms. Prisoners will be closed into those rooms. In case of open prison, there will be outer boundary only. Internally, there won't be cells, small cells. So that is the objective of open prison. See, understand, the concept of prison is that we have to reform these peoples. That is the basic objective. So this way, the reformation process can be conducted more effectively, and that's why there was a proposal. Okay. Now, for prisons, just remember this initiative, faster initiative. The name itself is self-explanatory. What is faster? Fast and secured transmission of electronic records. In a very simple sense, let's say some court has issued some bail order. Now those papers will go from court to jail. Sometimes this may take time, so that's why what is being done, this entire process is being done electronically. That simply means computerized. For this purpose, we have a faster system. So in a simple way, this will be used for the communication of the bail order from the court to the prison authorities. Okay. Now in this context, 2 3 important committees are mentioned. One is AN Mullah committee. So this committee basically recommended a dedicated service, just like we have all India services. For police, IPS is there. For administration, we have IAS. Similarly, this also recommended all India service, which is referred as Indian Prison and Correctional Service. And it also recommended that those who are under trials, they should be separated from the convicted. Convicted basically means they are punished. Let's say they are hardcore criminals. Let's say someone is convicted of murder or other serious issues. When we are keeping under trials with them, the chances of these under trials being turned into a hardcore criminal are quite high. So that's why this committee said we should keep under trials separate from those who are convicted. That simply means frame a boundary so that they are not able to interact with the each other. Why? Because our objective is reformation. But if they will interact with the convicted people, chances of them being turned into hardcore criminal are quite high. So these are 2 important suggestions. Keep under trials away from the convicts. Apart from that, there is Amitav Roy committee that recommended fast track courts. That's one thing. And exclusive women's prison. So these are 2 important recommendations. Now, why prison reforms are necessary? Understand, we have already discussed that more than 50% of the under trials, more than 50% of the prisoners are under trials. That simply means their guilt has not been proven as of now. Still, they are in jails. So that's why we need to have these kind of reforms in the system. Just a second, please. Okay, so roughly 73% of the jail inmates are under trials. Their crime is not proved as of now, and that's why there is a overcrowding also. Overcrowding basically means more than capacity. Apart from that, there are vacancies of staff. The staff is not well trained, and we don't have adequate women facilities. So these are some of the issues. Okay, next topic is related to crime in India report. So basically, this is a report by NCRB. Now, what is NCRB? National Crime Record Bureau. We have already covered. It was set up on the recommendation of Tandon Committee. It is under Ministry of Home Affairs. Usually, it releases a report that what is the statistics of crime in our country. So there are a lot of crimes mentioned in this report. I'm just giving you few important trends which you can use in your mains answer. In prelims, there is a very little chance that they are going to ask a statement from this, but in mains you can specify. For example, because of digitization, what has happened is that cybercrime has increased by 31.2%. Even if you are not able to remember the exact number, just understand that cybercrimes are increasing very fast. Why so? Because of adoption of digital technology plus lack of digital awareness. So that's why cyber crimes are increasing. Apart from that, the cases against scheduled tribes, they have increased by roughly 28%. Cases against children has increased by roughly 9%, and cases against women has increased roughly by 0.7%. This is in comparison to previous year. So even if you are not able to remember the exact number, just understand cyber crimes and crime against a scheduled tribe, they have increased by roughly 30%. What does that show? It shows that the crime against the vulnerable section, they are increasing. Similarly, crime against children are also increasing. For example, 10% increment is there. So this is how you can use this data, that how we need to strengthen our judicial system, police system, so that we can address these issues. Next is also related to NCRB report. So NCRB report on accidental death and suicides. Now again, there is a very little possibility that question in prelims will be there from this aspect, but from mains point of view, you need to understand 2-3 things. A, the suicides has increased, and states like Maharashtra, Tamil Nadu and Madhya Pradesh have highest number of suicides. The male-female ratio is roughly 72-27. Again, very high disproportionate amount of males commit suicide in comparison to female. Again, the issue itself is societal issue. We have to look into that. Now, roughly 6.3%. Again, even if you don't remember the exact number, roughly 6% of the suicide cases are related to farmer suicide. You can connect this to the agrarian stress, that because of declining productivity in agriculture, because of rising debt, the farmers are committing suicide. So what government need to do? Government need to formulate the proper policies. Apart from that, there are various initiative for mental health. For example, Manas is there, Telemanas is there. What is the concept of Telemanas? In a very simple sense, you are going to call someone and they will provide you the psychological support. Similarly, we can see that there are a lot of suicides related to children, because of the rising competition and because of the rising expectation of parents. So what is your responsibility as a part of society? We have to make sure that we talk to those people. uh, we should talk to our siblings, our friends, our colleagues, everyone. See, suicide is not a individual issue, it is a issue of society. As a society, we create circumstances. This is important concept of sociology also. Okay. Okay, now what are the initiatives taken by the government to prevent suicide? So two important initiative which you can quote in your mains answer. One is Telemanas and second is Mano Darpan. Okay, next is related to IT rules 2025. Now understand, there is one term in these rules. Actually, these are amendment of 2021 rules. 2021 rules were the base. Now in 2025, these rules were amended to address the problem of SGI. What is SGI? Synthetically generated information. In a very simple sense, this information is not actual information. It has been generated synthetically. That simply means it appears that it is correct information, but it is not. A more simple term for that is usually the term deep fake. What is deep fake? It simply means the content is fake, but it appears that it is genuine. Let me explain it again. The content is fake, but it appears as if it is genuine. So with the help of AI, a lot of deep fake content is being generated. To address this problem, the government has amended these IT rules. And these new rules will be effective from November 2025. In this context, 2-3 important terms are there. One is SGI. SGI, as the name suggests, synthetically generated information. This information has been generated artificially. It is not genuine, it appears genuine. Okay, in this context, just remember this term deepfake also we have already covered. Now these were the original base guidelines, IT rules of 2021. Now in this context, two terms are there which are important for understanding this entire issue. One is social media intermediary. Let me explain with the help of one simple example. Let's say you have posted a reel on Instagram. So you are the content creator or poster. I am watching that reel. So we are able to interact with the help of some platform. In this case, Instagram is that platform. So that is social media intermediary. The intermediary is facilitating the communication between two parties. On one side, you are there, content creator. On another side, I am there, content consumer. Okay. So in this case, the communication between the content creator and content consumer is possible with the help of social media intermediary. But certain platforms are quite significant, quite big. They are referred as significant social media intermediaries. These are very common social media platforms. These are big social media platforms. For example, Instagram is there, WhatsApp is there, Twitter is there, and so on. Okay, that is the major difference you need to understand. So what is SMI or social media intermediaries or SSMI? They enable the interaction between the two or more users. So you are content creator, a lot of people are going to watch your reel or YouTube short. So in that case, YouTube is the facilitator. Getting my point? So that is the social media intermediary. These guidelines are saying that it is the responsibility of the social media intermediaries to label the content as synthetically generated if it is generated so. Let me simplify. You posted a reel. That reel has some AI generated content. It is the responsibility of that platform. Let's say you are posting that reel on YouTube. So it is the responsibility of YouTube to label that content as AI generated. Okay, how much labeling should be done? So basically, as per the guidelines, roughly 10% of the surface area should show that it is AI generated. If it is a visual content, 10% of the area should show that it is artificially generated. If it is audio content, the first 10% of that audio should specify explicitly that it is synthetically generated. That is the responsibility of these intermediaries. What will happen if they do not follow these guidelines? We understand there is a concept of safe harbor. In a very simple sense, whenever any content is posted on social media platforms, even if it is offensive, social media platforms are not responsible for it. It is the content creator who is responsible. Social media platforms are just intermediaries. They have the immunity. This provision is basically referred as safe harbor. But if government provide certain guidelines to these social media platforms, and if they fail to comply to those guidelines, in that case they will lose this immunity. So just remember the concept of safe harbor. Safe harbor basically means social media platforms are immune. They are not liable for the content which is posted on them. But if government say, okay, follow these guidelines, or government say remove this content, and if they fail to do so, then this safe harbor provision or safe harbor protection, this will go away. That simply means their immunity will go away. That is the concept. Okay, so the government has specified the new amendment. As per that, it is the responsibility of the social media platforms to define or basically label these synthetically generated information. So they need to label. Okay, now if it is visual content, the content should have at least 10% of area. Let me simplify. Let's say there is a reel. On this reel, on this much part, it should be explicitly visible that it is AI generated. Let's say this is your entire screen. So on this part, it should be explicitly visible that it is AI generated, so that user can get to know that this is something which has been generated artificially, not some genuine content. Similarly, if it is audio one, so it need to explicitly mention that it is artificially generated content. Similarly, in case of audio, initial 10% should show. Okay. Now, if they fail to do so, then they are liable. So that is the concept which is specified in these recent guidelines. So if they fail to comply, the platforms may lose the legal immunity. What is the name of this legal immunity? Basically, this is referred as safe harbor protection. Okay, we have covered it in previous months as well. So just understand this concept. Apart from that, there is a concept of watermarking. See, just like on page, whenever a page is printed, there is a concept of watermark. For example, if you see any coaching magazine, so they usually put their watermark. Similarly, on the content also, there must be a watermark so that we can trace the person who has created this content. In a very simple sense, a unique identity should be generated for each content so that we can trace the user. See, with the help of AI, new content can be generated, but over a period of time, this is going to create more problems. That's why the government is saying it is the responsibility of social media platforms to label this content and to provide a unique identity to this content, so that if we want to trace the uploader or creator, we can trace with the help of this unique identity. That is the crux of these recent guidelines. In case of China, there is a mandatory AI labeling rule. That simply means if you are posting any AI related content, you will be given a unique identity so that social media platforms can trace you. As simple as that. Okay. Next is related to regulation of India's pharma sector. Now, there was a controversy related to cough syrup. Now, the problem is that in our country, the rules and regulations are not followed strictly, they are not implemented strictly. As far as pharma products are concerned, two important things are there. One is this legislation, Drugs and Cosmetic Act of 1940, and subsequently there are drugs and cosmetic rules. So this is the legal provision for pharma sector. Apart from that, there is a body. The body is CDSCO, that is Central Drug Standards Control Organization. This is under MHA. So this is the legislation. This is the body responsible for implementation of these provisions. What was the controversy recently? So ethylene glycol was available in the cough syrup. Ideally, it is used in industries and it is not safe for consumption. And why it was used in cough syrup? Because it is a cheaper alternative. So that itself shows that yes, the rules and regulations were not followed, and that is why there was death of a lot of people. Now understand, one issue is that it is a health concern. A lot of people lost their life. Another issue is that at global level, it is going to have a bad impact on India's image. Why I am saying so? India is considered as a pharmacy of the world. We export a lot of pharma products. Now, if we are not following rules and regulations clearly, that simply means there will be trust deficit. And therefore, what will happen? The countries may not be interested to purchase our products. In long term, it will have adverse impact on our brand image of Indian based pharma products. That's why it is necessary that government should take steps not only to save our lives, of course, that's prime factor. Apart from that, from economic angle also, this is going to have long term adverse consequences. So you need to remember this dimension. Okay, now first thing first, as I have mentioned, this was the name of the toxic substance which was found. Now how UPSC is going to frame question from this? See, very simple question can be framed in this way, that ethylene glycol is a common substance used in the pharma products. Now if you are not aware of this controversy, you may think that okay, it may be used in the pharma sector, but the entire controversy was around this chemical. Therefore you should know that it is not used in pharma sector. Okay, apart from that, there is a lack of mandatory recall law. Let me explain it with the help of one example. Let's say a cough syrup batch has been generated. Let's say 100 bottles were, or 1000 bottles were produced. They are in market now, and there is some issue with that cough syrup. In a country like India, we don't have a recall legislation. What does that mean? If some product is defective, it should be responsibility of manufacturer to recall those product. That simply means to take those product back. We don't have any legislation like that. This itself shows that there is a huge legislation gap, and that's why these rules and regulations are not implemented strictly. So these are some of the issues related to this pharma sector. Next is related to tribal governance. So recently it was in news because in tribal dominated villages, various initiatives were taken. Now understand, for the tribal welfare, there is Adi Karam Yogi Abhiyan. As a part of this initiative, basically, tribal communities or tribal villages have adopted the Vision 2030 declaration. In a very simple sense, the objective is to ensure the holistic development of tribal areas. Now, what is this Adi Karam Yogi Abhiyan? In a very simple sense, our objective is to develop a decentralized tribal leadership. In a very simple sense, we have to select people from the tribal areas. We have to train them so that they can lead those areas and they can provide better governance in those areas. That is the objective of Adi Karam Yogi initiative. In a very simple sense, train the leadership for the tribal governance. Okay, so that was this. Next is related to promotion and regulation of online games. See, last month we have discussed that government had introduced a new legislation to impose a ban on various category of online games. Now the rules has been notified. So two important things are there in this case. Number one is the online games are categorized into three categories. One is e-sport. E-sport basically means a general sport is there, then there is a e version. E version simply means online version. For example, you play cricket, so there is a online version, that is e sport. Okay, second is online social game, and third is online money game. Now understand, not all type of online games has been banned. The first two categories, they can operate, but the online money games, that is OMG, easy way to remember, OMG, this has been banned. OMG, online money games, this has been banned. So for this entire process, that means how we are going to regulate which is banned, which is not, we have a specific body, and the name of the body is, just a second, it is OGAI. What is OGAI? Online Gaming Authority of India. So this is going to regulate the online games, and this is going to maintain the database of those uh, online games which are allowed, and it is going to take action against those which are not allowed. Which one is not allowed? Just remember, OMG is not allowed. What is OMG? Online money games. Why it is not allowed? Again, it had a lot of adverse impact, it had addiction like issues, and it was kind of gambling. That's why government took this action. Okay. And last news in the polity section is related to postal ballot. First, understand 2-3 terms. Postal ballot basically means you as a voter will receive a ballot paper online. Okay, you got the ballot paper, you are going to fill the choices. Let's say a ballot paper is having 4 choices, A, B, C, D, 4 candidates are there. You selected candidate number B or candidate number C. Okay, now you are going to send it back to the election authorities. This is postal ballot. Now you have voted through this postal system, other people have voted through EVM. How this voting will be counted? For that purpose, recently Election Commission has issued guidelines that first the counting of postal ballot should be done, and then the EVM vote should be counted. First postal ballot counting should be done, then EVM voting. Now understand, this is one guideline, that's why it was in use. Second thing is that who are eligible for these postal ballot? Number one is service voter. Service voter basically means, let's say army personnel are there, they are posted in different areas, so they cannot come to vote. So for them, postal ballot is allowed, and their spouses also. Okay, that's one thing. Second category is special voters. For example, president is there. So in this case, special voters are allowed to vote or cast their vote through postal ballot. Third category is a special category, or basically the people who are absentee voters. Now, what is the meaning of this term absentee voters? Basically, senior citizens who are above 85 or person with disabilities or differentially abled people. So 3 type of people: service voters, for example army personnel; special voters, for example president; absentee voters, for example senior citizens with the age of more than 85, or person who are differentially abled. Okay. Now if voting will be done, first postal votes will be counted, and then remaining votes which are casted through EVM, they will be counted. So that is the crux of this entire issue. And with this, we have covered the polity section.
And in polity section, there is a land registration system. Now understand, in a very simple sense, land is a state subject. In our country, as of now, the land registration system or land titling system, that is based on presumption. So there are two major type of land titling system. One is presumptive and second is conclusive. We will talk about it. But before that, let me explain. Whenever there is a transaction of land, that simply means the seller has sold the land to the buyer. So S is seller, B is buyer. They need to process this entire transaction with the government focus, and what is being referred of G in this case. Okay. Now there will be 3 major documents related to land. One is sale deed. Sale deed basically means a document related to sales. Deed is nothing but a legal document in simple sense. Okay. So that is a legal document of transfer of property. In this case, S is going to transfer the property to B. Okay. Now understand, the registration will be done in registrar office as per Registration Act. Then there will be record of rights. This is basically referred as khata or patta. You might have heard these terms in our local parlance. So they reflect ownership, soil type, and different other information. And this is maintained by Revenue Department. Now understand, this is maintained by Registrar Office. This is maintained by Revenue Department. And there is a survey map. Let's say you have purchased this land. So you are the owner. A is the owner. But what will be the boundary of this land? That is reflected through survey map. So survey map is being maintained by Survey Department. So 3 departments are there: Registrar Office,
revenue department and survey department. This is going to specify the boundary. And that's why this entire land registration is quite complex. Why this was in news? Because of a Supreme Court judgment against the state of Bihar. But before that, let me explain the land titling. So one is presumptive land titling system. Presumptive basically means it is presumed. Why it is presumed? Because if you are having documents, it is presumed that you are the owner. Now understand it using one simple example. Let's say S is seller, he is buyer. So S has sold his land to E. This entire process will be done in the government office. Now, what happens is that in presumptive land revenue system or land titling system, if there is a dispute in this land, let's say S committed some kind of fraud and documents were posed. Posed basically means fake documents were there. In this case, government is not going to take any responsibility that this transaction was done in government office, so we are going to verify it. No, this entire headache is of B. If you are purchasing land, first verify that the person from whom you are purchasing this land, that person is actual owner, that person is the owner of that much amount of land which you are buying. This is presumptive titling system. In this case, it is assumed that land is being sold if there is a sale deed exists. That simply means paperwork exists. If any dispute will be there, so let's say the seller did some kind of fraud, so B will also be a party. Why? Because you have purchased a fraud land. In a very simple sense, let's say the seller committed some kind of fraud and he tried to sell the government land itself. We purchased it. Now when there will be litigation, then S will be a party, B will also be a party. That is presumptive titling system, and that's why there is a high risk of litigation also. Litigation basically means case. Okay, government responsibility is just government is going to register it. Government will say, okay, you are the seller, you are the buyer. Government will say you have already done the background check, we will just register it. Let me give you a very basic example. Let's say there is a marriage, so government is going to register it. But what if one partner turn out to be a fraud? Government is not going to take any responsibility in that case. Government will say, okay, you have done your marriage registration in our office, so we assume that you are married. That's it. Then there is a another system which is referred as conclusive titling system. Conclusive basically means, as the name suggests, that government will make sure that you get your right. That means if you have purchased the land, a proper paperwork, then in case if there is a dispute, you will not be party to the dispute. Government will support you. Why? Because this entire process was done in the government office. The government confer the ownership in a very simple sense. Government will take care of this fraud thing. Government will say, okay, if it was done in government office, yes, you own your land. So buyer will not be victim in this case, and the government will be the party to the dispute. That is something which is referred as conclusive titling system. So we have covered two type of land titling system. One is presumptive. In this is presumed that you are owner if you have documents. And in case of conclusive, if there is a dispute or if any fraud is being committed by the seller, in that case, government is going to support the buyer. Why? Because this entire process was done in government office. Okay. Now let's come back to the original topic, land registration system in India. So why it was in news? First thing first, the state of Bihar was updating land record, and Supreme Court in Salimullah versus state of Bihar called for reforms in the land registration and titling. Okay, now understand two three things. A, you need not to go into too much detail. You already know the conceptual part, that is how land is being registered in our country. Okay, now the problem is the system is quite old, the rules are old and they are quite messy. Plus, since land is a state subject, there is a state to state variation. Okay, land is a state subject, but registration deed, this is in concurrent. Okay, these are the issues. We have already covered these Now, in K Gopi versus sub registrar case, again you need to mug up this case, but you need to understand the meaning of this statement. Sub registrars have ministerial role only; they cannot verify the ownership or title. In a very simple sense, government will just register it. Why? Because we follow presumptive land titling. The government will just register it. Government will not take any responsibility. Government will not verify whether your claims are right. It is your responsibility as a buyer to verify that. But in case of conclusive system, government will confer the ownership right. That is a difference. Now, various initiative has been taken to modernize the land records. For example, Digital India Land Record Modernization Program. And there is a unique identity for a land parcel. It is referred as Bhu Aadhaar. Is a 14-digit number. Okay. Apart from that, various state government initiatives are there. Just go through them. Very basic thing, nothing extraordinary in this. Next is related to digital personal data protection rule. Now understand, for the protection of digital personal data, three things are there. Digital personal data. We have DPDP Act. What is DPDP? Digital Personal Data Protection Act 23. This act is of 2023. Now new rules were issued under this act, and these are DPDP rules 25, and that's why it was in new. Okay, first thing first, which ministry is there? MEITY. Examiner can set a trap by changing the ministry. So it is Ministry of Electronics and Information Technology. Okay, now understand, the basic objective is to protect the personal data. Okay, there is a compliance period for the organizations. Compliance period basically means now the government has issued rules, so you have 18 months to follow these rules. That means set your house in the order, and then start following these rules. Within 18 months, you should be ready to implement these rules. That is the meaning of compliance period. Again, examiner can set a trap by saying 24 months or any other duration. Now, what are the obligations of data fiduciary? First thing first, who is a data fiduciary? In a very simple sense, data fiduciary basically means who hold your data. Hold data. So, let's say a company C is there. This company store your data. Okay, you have given some kind of data to it. So, what are its obligations? A, without consent, it cannot do. And you have right to withdraw your consent. Again, quite simple, because it is your right to privacy. Then there is a concept of erase personal data once the purpose is fulfilled. Now, this is similar to right to forgotten. Forgotten. What is right to be forgotten? Understand. Right to be forgotten basically means for digital data, you have right to get it removed from the digital platform. Okay. And the data fiduciary need to maintain this data for 1 year unless explicitly specified. Again, duration can be changed by examiner. And if there is a data breach, these fiduciary need to notify the government, and they need to publish data protection officer details, that who is the data protection officer in your organization. Okay, so these are some of the provisions. And if there is a request, you to respond within 90 days, you means data fiduciary, and there should be a special protection for the children data. These are the obligations. Now, how to ensure that these obligations are fulfilled properly? For that, we have DPBI. What is DPBI? It is Data Protection Board of India. Okay, how many members will be there? There will be 4 members. What will happen if you are not happy with the judgment of DPBI? So you can appeal in TDSAT. What is TDSAT? It is Telecom Dispute Settlement Appellate Tribunal. Understand? We have a body named as TRI, and this is important. Question can be asked from this. What is TRI? Telecom Regulatory Authority of India. The appeals of TRI are appealed in TDSAT, Telecom Dispute Settlement Appellate Tribunal. Similarly, the appeals of DPDI are also appealed in TDSAT. Examiner can set a trap that the appeals will be directly appealed in High Court, or maybe not appealed, or something like that, or maybe to the Government of India. Okay, so just remember this trap. Now, as far as this act is concerned, the logic is quite simple. With digitization, the data protection is necessary. Okay. Now, understand what if these data fiduciary do not follow the guidelines. So there are various penal provisions, financial provisions. 250 crore fine for security failure, 200 crore for breach related violations, and 50 crore for other violations. Please remember the factual information because examiner can change these information and there is a high possibility that there will be question from this particular topic. Now there is one more conflict. Understand. First, let me simplify this conflict. We have two acts. One is DPDP. DPDP basically says that your digital personal data should be protected. And there is RTI. What is RTI? Right to information. So RTI says that personal data can be disclosed if it is useful for public purpose. Personal information can be disclosed if it is useful for public purpose. That is section 8 of RTI. But section 44 of DPDP says that it cannot be done because it will violate privacy. In a very simple sense, the section 44 of DPDP amend the RTI and now there is an exemption for all personal information. Now let me simplify. Is a government official? How much is the property of that government official? That is basically his personal information. But under RTI, that could have been disclosed for wider public purpose. Okay. But now under DPDP, because it is personal information, it cannot be disclosed. And if it is disclosed, there is a provision of these kind of penalties. So that's why it is criticized that this DPDP has kind of overshadowed the Right to Information Act. Just understand the conflict. In prelims, sections can be asked. So just remember section 44 of DPDP and section 8 of RTI. Okay. And examiner can just frame the statement in such a way just to test whether you understand this issue or not. Okay. These are some of the common issue. Again, important for me is just go through them. I have already explained everything. Next is related to India AI governance guidelines. Name itself is self-explanatory. Guidelines issued by the government for the use of AI. Okay. We have India AI mission. Now, what are the issues in our AI governance? See, first issue is digital divide. Just understand the meaning. Two people are there, A and B. A have access to digital information, B don't have. So there is a difference or a divide between them. This is referred as a digital divide, have and have not. Some people have access to this digital technology, so they are in good position. Some don't have, so they are in a bad position. Second is algorithm discrimination. In a very simple sense, we are talking about AI, but this AI is being trained by human beings. So we all have biasness. So what if that biasness is reflected in the AI itself? Let me give you a very simple example. We all feel that people of our state or people of our caste or people of our religion, they are kind of superior. Some kind of biasness is there. We are training the AI model. Now, the AI will also start believing this. So when you are going to ask who is the right person for this job, then there will be biasness. This is basically referred as algorithmic discrimination. Now, this is being said that ultimately human biasness will be now transferred into the AI. Rest of the issues are quite common. Next, there is one more issue related to IPR. Now, understand what is IPR. IPR is intellectual property right. What is intellectual property? Intellectual property is creation of human mind. Created it. It is something which you created using your brain. So let's say you have written a book. Now this is your creation, your creative work. So you can get copyright for this. Problem is that these AI models are being trained with the help of copyrighted material. Let's say you published 4 books. AI models are being trained using those books without even your permission. Now, these AI models are trained enough so they can write 5th book based on your content and you will not get any credit for that. So that's one issue. Second issue is that since it can generate new content, it is basically referred as Gen AI. What is Gen AI? Generative AI.
Who is going to have copyright over that Gen AI content? So that is another issue. Apart from that, there is issue related to AI overview. Understand this as well. For example, you searched a term IPR related issue. Now, when you are going to use Google, it is going to provide you overview on the search page itself. This you got the overview. You will not visit those website. Why you will not visit website? Because you have already got the overview. These websites are saying that this is loss of our revenue. Why it is loss of revenue for them? Because the user is not coming to the website, and since user is not coming to the website, it is the Google who is having the control over their revenue. Getting my point? So websites are saying Google is using our content to show overview, and therefore we are going to lose revenue because now the user will not come to our website. So these are some of the issues. Okay, rest everything is quite common. As far as AI is concerned, Europe was the first to regulate AI through Europe AI Act of 2024. And there was a Blashley declaration which was signed by the countries of European Union to talk about the opportunities and risk by the frontier AI. Now understand, just remember this Blashley. Now two type of statement can be framed from it. One is who signed it, and it is related to which sector. It could be related to climate change, environment, or maybe clean energy or something like that. है ना? So just remember this is related to frontier AI. Frontier basically means advanced AI technology. Now, what is India's AI mission? So it was launched in 2024, and objective is to deploy 10,000 GPU. Please cover this topic of CPU versus GPU versus TPU. This can be asked in exam. Okay. So basically, government is setting up the AI infrastructure which can be used by the companies. Let me give a very basic example. Let's say you don't have your private study room and you want to study. Okay. So what government is doing? Government is setting up a library. You will use the facilities of library to study. Similarly, you want to use AI, or you want to develop some product using AI. For that, you need GPU, but they are very costly. So you don't have that kind of infrastructure. What government is doing, that we will set up the infrastructure. You use this infrastructure to continue your AI projects. Okay. Then there is a Coleridge dilemma. What is this dilemma? Understand. When AI is new, and it is new, countries hesitate to regulate it. Why? Because if they will regulate too much, it will hinder the development of AI. But once AI is well developed, then it will be very difficult to regulate. Why? Because now AI is changing very fast. The law does not change that fast. Okay, this is major issue. Now understand in a very simple sense. For example, there is a deepfake. What is deepfake? A content which is fake but which appears genuine. Now, the moment we will have law on this, by that time there will be much more serious applications of this deepfake, and that's why it is often said that in this case, technology is changing faster than the rules and regulation. Next is related to tribunals. Understand? In a very simple sense, tribunals are the specialized courts. Okay. Now, what was the entire dispute? First, understand, for the appointment in the tribunals, the Tribunal Reform Act was enacted in 2021. Understand? Tribunal is a quasi body, quasi judicial body. So, what will happen? If there is a case of special nature, it will be sent to tribunal. For example, let's say I'm oversimplifying. There is a income tax related case, so it will go to income tax tribunal. Why not to the regular court? Because this is a complex issue, and for that we have a specialized body. Okay. Now understand, when cases are going on in tribunal, in lot of cases, government itself is a party. That means cases filed against government. So when government is appointing the members of tribunal, it is a conflict of interest, and it is a violation of separation of power. How it is a conflict of interest? Government is a party. That means case is filed against government, and government itself is appointing the members of the tribunal. That is why the court has struck down this Tribunal Reform Act of 2021. So, first understand what were the provisions in this Reform Act and what the Supreme Court said. Okay. First thing first, what was the tenure of the members, 4 year was the tenure, and minimum 50 years was the age criteria. The Supreme Court said that minimum tenure should be 5 years at least. Second, the court also said that those who have experience of more than 10 years in the legal field, they should be considered for the appointment in this case. That means lawyers having minimum 10 years of experience. Why to fix this criteria of minimum 50 years of age? Why not to allow young talent? That was the second argument. Third argument is related to the appointment, and that is the most important point. Second. Okay. Now understand, for the appointment, there will be a search cum selection committee, which will be chaired by the Chief Justice of India. Okay. So there will be a person who is going to be CCI. Then there will be 2 members who are going to be the secretary. Secretary basically means government officials in a very simple sense. So one will be CCI, plus there will be 2 secretary, and 1 member will be of tribunal. For example, we are appointing member for a tribunal. So the chairperson of that tribunal will be 1 member, 2 member will be the government officials, and 1 will be CCI. The Supreme Court said that in this case the legal members are less. From judicial side there is CCI, and there are 2 government officials. So that is a clear-cut violation of separation of power, and that's why the court struck down this particular amendment. Okay, extremely sorry for that. So the court has previously given various judgments in which it has specified that in tribunals there should be a dominance of judicial members. Why? Because ultimately they are going to decide things, and in certain cases they have to take decision against the government itself. So this was highlighted by the court in Madras Bar Association case. These are multiple cases, so just remember MBA, that is Madras Bar Association. Okay. Apart from that, the court also said that there is a need to set up a NTC. What is NTC? National Tribunal Commission. So this commission is going to be responsible for the appointment. Okay. And till the time this NTC is set up, there should be a separate wing or separate kind of body within Ministry of Finance. Now this is important. Examiner can set a trap that this need to be in Ministry of Law, but it need to be in Ministry of Finance for the purpose. Okay. Rest everything is quite common. We have already discussed these. Tribunals are set up as per Article 323A. Parliament is going to set up the administrative tribunals, and for others there is Article 323B. What was the first tribunal? Income Tax Appellate Tribunal. Now understand this thing. You might wonder that tribunals came into picture in a very later stage after 42nd Amendment. But this tribunal was set up much before that. So after 42nd, we provided a constitutional basis for it. Okay. Next is related to legal aid. Again, it is a very simple topic. Why it was in news? Because it completed 30 years. But you might wonder how come something can complete 30 years when the act was enacted in 1987. It was enacted in 1987, but the implementation started from this second 1995, and that's why it completed 30 years. So first, again, examiner can set a trap that it was implemented immediately after the enactment. Okay. Now, as far as Lok Adalat is concerned, understand the name itself is self-explanatory. Lok plus Adalat. So it is a method of alternative dispute resolution. What is this ADR? Without going court, dispute resolution without going court. Okay. So alternative to what? Alternative to regular judicial system. So what is the benefit? A, this is less complex, plus it will also reduce the burden on the judiciary. Okay. First such Lok Adalat was organized in Gujarat in 1982, and subsequently it was given statutory status under Legal Service Authorities Act of 1987. Okay. Which was amended in 2002. Okay, these are already covered in Lakshmikant, so nothing new is here in this case. Please go through that. All you have to do in terms of current affairs is you should know that it completed 30 years. That's it. Rest everything is covered in Lakshmikant. Understand one more thing. Please do not try to cover static part through current affairs. What do I mean by that? That you are not covering your static part properly, and then you think that okay, I will cover only those static portion which are in current affairs magazine. No, that is very wrong strategy, and it will waste your attempt. So please don't do that. Okay. Next is related to Supreme Court assent on bills. So understand, in April, the Supreme Court had given a judgment that there is a timeline for the governor to approve the bills. Just let me explain. Tamil Nadu versus the governor of Tamil Nadu. That was the case. Court said that there will be a timeline. Subsequently, the government of India through president filed a presidential reference. What is presidential reference? In a very simple sense, president asked for the opinion of the court. Okay. Subsequently, as a result of that 16 presidential reference under Article 143, the court said that no, we cannot specify any timeline. If it is not mentioned in the constitution, how judiciary can specify a timeline? So that is the judgment. Okay. Now this is different from the previous judgment of April. In April judgment, basically the court had specified a timeline of 3 months. Just remember this thing. But the court also specified few issues. One is there is no concept of deemed assent. What is this? In a very simple sense, let's say there is a timeline of 3 months. What if the governor do not take any action till 3 months? In that case, it will be considered as past. Understand, this concept is referred as a deemed assent. That means it is considered that you have approved it. In case of USA, this principle is there for the president. But the court specified that it is not mentioned in our constitution, and therefore it will not be applicable in our case. Secondly, the court also said that the governor and the president cannot sit on the bills indefinitely. That's a violation of the federal structure. Why it is a violation of federal structure? Understand. The Assembly of a state has passed a bill. The bill was referred to the governor. Now, governor is not taking any action. Technically, it is against the will of the people. Why? Because the assembly is elected by the people for making law. Now, if governor is not going to approve it, that's a violation of this federal structure, because governor is appointed by the central government. So in this case, it is criticized that governor is acting as agent of center. Okay. And the rest is the court can intervene if the intention of the governor or the president is malified. Malified basically means bad intention is there. So there are three important things. In a very simple sense, the court said that no, we cannot specify any timeline, but it does not mean that the president or the governor will take infinite amount of time to approve these bills, and there is no concept of deemed assent. Deemed assent basically means it will be approved automatically if no action is taken within a time limit. There is no such concept in our constitution. This was specified or clarified by the court in this presidential reference. Okay. Next is related to use of AI in the judiciary. So recently, a report was released by the Supreme Court Center for Research and Planning. Understand, again, very low possibility to ask a question in prelims. In mains, of course, it can be asked. So I'm going to explain it from that perspective. First is, as we have said, that use of AI have privacy risk. Too much dependency on AI is not good, because there are biasness. Why there are biasness? Because ultimately, who is going to train them? Human beings. So our biasness will be reflected in the judgments of AI as well. And then there is a hallucination. In a very simple sense, it can create fake scenarios which does not exist. Ultimately, passing a judgment basically means the judge need to understand the scenario, different scenarios. It is not just a program that okay, this is a crime, this is the punishment. No, the judge need to consider a lot of circumstances, and that's why it could be quite risky to be over dependent on AI. Yes, you need to use AI in the better management of the cases, but ultimately the decision should be passed by the judge. So that is the argument, and we need to promote ethical use of AI, and all these things are already there. Next is related to prison in India, 2025 report. Again, it is also by the same Center for Research and Planning. We have already covered this prison topic the month of October magazine. So please go through that. In a very simple sense, just remember this one thing, that India follow the Nelson Mandela rules. What is this Nelson Mandela rules? So these are United Nations standard minimum rules for the treatment of prisoners. In very simple sense, we are going to treat prisoners like human beings. They are not animals. They should be treated like human beings. That is it. Just remember this Nelson Mandela rule. Okay. Rest everything is already there. We have already covered these issues in last month. Next is Model Youth Gram Sabha. So in a very simple sense, we are trying to bring young people into the third tier government. So integration of the young people into the third tier. So this is an initiative of Ministry of Panchayati Raj along with Ministry of Education and Ministry of Tribal Affairs. Okay, and the objective is to promote the participation of the youth at Panchayati level or at Gram Sabha level.